Okay. All right. So we'll get this started. Today is February 11th, and this is our obviously February Rainmakers call. Our guest today is Gene Trowbridge. Gene is, in my opinion, the far and away utmost expert on syndication law. And as Gene and I were discussing briefly before I had to jump off and resend the link to a few people, I believe in this market more so than ever before, probably. Brokers are, not simply just showing the properties, the great properties to their clients, watching their clients buy them and put millions of dollars in their pocket in some cases. They're now actually buying them. I've been invited to join in. I'm sure many of you on the call are getting these same emails. I've been invited to join in on at least a half a dozen partnerships or syndications over the past year, and I'm sure I'm going to get at least another half a dozen this year. Many of the people I know, some of them I've never spoken with, but that just to me cements in my mind that uh, brokers should be participating in a call like this, should be hearing what Gene has to say. And without any further ado, Gene, I'm going to turn it over to you, and we are recording. Go ahead.
Okay. Thanks, Neil. Good morning, Robert. Good
Good
morning, Mike.
morning.
How are you? I get all of your emails. I see all your stuff, how active you are, Robert. So, anyhow, I'm Gene, and I've been one of you guys and ladies, Heather, hi, for a long time. I got my pin in 77. Many of you weren't born yet. Daryl, I don't think you were even born in 77, were you? So, so anyhow, and that's I'm a three-digit number, and someone always can beat me, but I'm number 773 in the hierarchy of the CCIMs, and been around a long time, and was a syndicator. Probably the most important thing to know is I was a syndicator for about 20 years, and in my mid 40s, I decided for a couple of reasons, I didn't want to be a syndicator anymore. So I went to law school. And at the ripe old age of 45, I was sworn into the California bar, and I've been doing uh, securities work ever since then. And the strength that I have that I bring to clients in my firm is that I know both sides of the industry pretty well, and that's good for mentoring new people. I can be quite a help when we have new people. One thing I want to say right now, Neil, is if I send you, I'm going to send you a link to the PDF of my new book. My fifth edition is just out. In fact, it's not even on Amazon yet because I'm still playing with the artwork on the cover. But I have the fifth edition out as of the first of this month, and I'll send it to you, and you can send it to everyone. My book is called It's a Whole New Business. Some of you who know me may even have an older version, but every time subs there's substantial changes in securities laws or something that I think you should know about, I write a new version. I know many of you know Mark Levine at the university, and I got an email for him that he's publishing his 56th edition of his tax book, which I found was interesting because after my first edition was out there for a while, he called me and said, there must be a typo or something. You've got to come up with the second edition. You can't have an edition that's out there for 3 or 4 years. So I'm on edition number 5, and I think I have all the typos worked out this time. I'm not exactly sure. Well, and Neil talked about brokers stepping into the business world and becoming syndicators or investing in. And I know from my own experience and experience of others how people get to be syndicators, if I can use that word. That means you just pooling money from other people and going out to do something together. We get to be syndicators because we find a piece of real estate that if we do have enough money to buy it ourselves, we don't want to buy it totally by ourselves because maybe then we'll be out of money for the next deal, or we just want to bring in people that we know who would like to share in the opportunity that we find. And it's not so much, I'm sure they're selling, but it's not so much selling in there. As you're getting started, you just simply are reaching out to people who know you, know how experienced you are in whatever part of the real estate business you're in. And then if you can present to them an opportunity, they'll be interested because somewhere along the line they're already thinking that you're doing business, and gee, if they weren't working a full-time job and doing whatever they do, they'd like to do what you do. So opening a syndication or a group investment to them is kind of attractive to them. And that's how I got started. I had 3 or 4 pieces of real estate myself back in Minnesota in the late 70s. And I found an apartment building that I thought would be a good buy, but I couldn't do it myself. So I reached out to 3 people I had gone to college with. And at that time, we'd all, bought a house, and I guess we all had life insurance. So we had some extra money to invest. And we bought this property, and I learned what it meant to be a syndicator. I don't have any slides or anything in my presentation. I've got a list of things that I'd like to talk about, but I'd also like to take your questions. And I don't know how to do it. I guess if Neil, if I could have everyone on microphone, if they're thinking about doing a question, just speak up and ask, as opposed to doing the chat. I'd rather just do it that way if you don't mind.
No, Gene, that's fine. Anyone who has a question, just because a lot of you I see are muted. I guess most of you are muted. If you have a question, just unmute. And Gene, do you want them to ask those questions now or near the end?
Oh, I think let's take the question when it comes up.
Okay.
In
All right.
case
You back out.
something interesting is said from this gray-haired guy, just interrupt and we'll ask the questions. So one of the things I think you need to know is when you put together a group, you are going into the world of securities law. My book is entitled "It's a Whole New Business." And when I wrote the book back at the first edition, back in '95 for a CCIM conference that was held in Reston, my point was to tell the commercial real estate brokers that, or the CCIMs, that you can't just go out and get 3 or 4 people or 10 people to buy a building and treat it just simply as a real estate transaction, because you are moving into a new area and you're moving into the securities world. And so now you have real estate laws to take care of, but you also have securities laws. And why is that? Well, when people like us go out and raise money from investors and put the money in deals, there is a need, at least from the federal government standpoint, to protect the investors. That's what it all started back in the 1931, 32, 33 area. There were no laws to protect investors. And so the first law came out and said, we're going to protect investors basically by requiring full disclosure. And so that leads us to today and things that you've heard of: private placement memorandums, operating agreements, subscription agreements. What we have to do is we have to take all the material facts that are out there, put them in writing, and provide them to the investors so the investors can look at those, make an informed decision before they invest. So that was the first securities law, and we're still operating under that law. And the second securities law was, let's regulate who is doing this. So that really created the issue of FINRA and broker dealers and getting licensed and all that. So there's one set of rules that protects investors from people, if you would, and another set of rules that protects investors from the transaction. Now, when we're doing our business, which is what I'm talking about today, is called private placements. We don't have to go to the SEC for a full-blown offering that we're going to put on Wall Street. There is a rule, a section of rules that helps people do um, private placements. The rule is that every securities offering has to go full bore through the SEC unless it's exempt. Well, that's the world we all work in and I work in, is exempt offerings. Uh, that's that's important, so we need to know about that. And then the other rule that deals with people, none of us need to be licensed. None of us need to be securities licensed to sell your own shares or units in your own offering. It's just like for sale by owner in real estate. You can sell your own real estate without having a license, but you can't sell mine. Okay. So when you bring out your own offering, you're selling your own offering, if you would. You're called an issuer, and an issuer doesn't have to have a securities license. So we really are not worried about licensing at all. We're only worried about, are we going to tell the investor everything they need to know so they can make that informed decision and protect us through our full disclosure and really protect the investors so the investors know everything that's going on. One of the things I learned from being a syndicator is an ill-informed investor is a pain in the butt, and always the investor that puts in the least amount of money is the largest pain in the butt. That's the way that goes. So if you're thinking of putting together people and you're going to enter the securities world, you need a little more education, and you probably need to hire some attorney to help you do your work. I'm going to give you a four-line definition of a security so we understand that. And this is out of a case that really came out of Florida in the 40s, and it came out of Ocala, Florida, really. Um, and it was a situation where people had an agricultural company, and and the agricultural company raised citrus and oranges and all that. And what they started to do is they started to sell small plots of land in their agricultural farm to investors. I mean, you couldn't stay there because the lot was full of trees, but if you were coming down for your annual vacation, you could visit your investment and maybe take a ride off. And the agricultural company said, you're going to buy your lot, and we're going to take care of everything that's on there. We're going to eventually harvest citrus. We're going to package it. We're going to sell it, and we're going to share the revenue with you. You just have to pay us the payments on the seller financing for the lot. Well, unfortunately, the company went bankrupt, and so the citrus production stopped, and all these people who owned lots still were required to pay payments on the seller financing, and they all raised up and hired some attorneys and said, we're not going to do that. The only reason we bought the lots is that we could get profit from the citrus farm, and then with that profit we could pay for the lots. And we didn't have anything to do with it. We were told in the purchase of the land, on the land contract, that the farm, it's called Howie, Howie would handle everything, and we weren't allowed to harvest the fruit or do anything. So it was kind of a passive investment, but heaven forbid, none of us would have bought a lot down there if it weren't for the Howey Company and what their promises were. So eventually, by 1940, after the securities laws had been in place for 6 or 7 years, this got to court. The landowners said, you sold us a security under a definition called investment contract, which no one knew what that meant, but it was in the document. And Howey said, no, 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 we just sold you the dirt. And it went to court many, many ways and got decided differently. It finally ended up in the Supreme Court. And the Supreme Court said this is the perfect example of what an investment contract is. And an investment contract is named in the definition of what a security is. And so they said for all times, an investment contract is an investment of money or anything worth anything, could be labor, in a common enterprise where you're investing with other people to do a project, whatever it is, with an expectation of profit from the investor standpoint, through the efforts of the promoter or the sponsor. So we have passive investors putting their money together in a project with an expectation of profit, but someone else is running it. So that's really the point. As I said earlier, the government had interest in protecting investors. So we're going to protect what the investor is selling, and we're going to protect who is selling it. So that's the Howey case. And if you ever read anything about securities laws, it always refers to that Supreme Court case as the definition of what a security is. So practically speaking, you go out and find 3 or 4 people to buy a Walgreens. You say, I'm going to raise the money. We're going to buy the Walgreens. I'm going to do all the management. We're going to share the profit. That's a security. You have 100 people. That's a security. So it all is, it really comes down to, are you investing money with an expectation of profit and someone else is running it? If you put 2 people together in an offering and they make all the decisions together and no one else is in charge of their money, then it's not a security. That would be called a member managed. But when you're in a manager managed, it's a security. Okay. Are there any questions right now? I said a lot right there.
Yeah, Eugene, it's Mark Hinkins. Thank you so much for the background. Clearly, it is a security. Does that mean that the investors must be qualified investors? And then my second question is, if a broker puts together an offering, how do we know that they got it registered with the FCC and it's all legitimate?
Okay, you brought up two important questions that I think we should cover. First of all, the securities laws looks at the population in two buckets: people who can fend for themselves and people who can't. Okay, and so they've defined the people who can fend for themselves as accredited investors, and everyone else is non-accredited. So you can imagine if they've decided, here's a whole bunch of people out here that can fend for themselves, we don't have to pay quite as much attention to them as we do in protecting those who can't fend for themselves. So right now there's about 18% of the households in the United States that qualify as accredited investors who can fend for themselves. When the rule of an accredited investor and a non-accredited investor was created in 1980, there were only 3% of households in the country that could fend for themselves. Salaries have gone up, net worth has gone up, people have made investments. It's easier to qualify as an accredited investor. The simple rules, there are a lot of rules, but the simple rules is if your household has over $1 million of net worth, not counting the primary residence, you're accredited. If an individual taxpayer earns over $200,000 a year, that individual is accredited. And if it's a married couple filing jointly, the number is 300,000. So there's a lot of other rules, but that's basically where it started. You got $1 million net worth, or your earnings are strong, you can fend for yourself. Now, this is back in 1980 when $1 million of net worth accounted for a lot. But back then, they allowed you to count the value of your house. 2008 came along, Dodd-Frank came along and said there are too many investors who are counting the value of their house in order to reach the $1 million limit. And we don't think that they really can fend for themselves. Example would be the people on the coasts who, in the 60s bought houses for $40,000. And now the house is free and clear and it's worth $2 million, and they're living on Social Security. And the government said, well, those people really can't take the risks that other people can. So in 2008, they took the value of your house out of your net worth calculation. But we're still up to the 18, 19% of households who are accredited, and that's a concern of the SEC. So that's the answer really to your first question. Is that okay, Mark?
Yes, you define what an accredited investor is. My follow-up question is, if you're offering this as a security, which you have to, do you have to be an accredited investor
Okay.
to take a slither of the investment?
And the answer is no. If you're the issuer, the for sale by owner person selling the securities, you're automatically defined as an accredited investor. Okay.
Okay.
Now, I think the second question you have is pretty important, especially for you, Mark, and anyone else who has broker responsibilities in their office. I know some brokerage firms that have in their contract with their salespeople that you cannot do a securities offering. Okay. I know some brokers who say, if you're going to do that, I need to sign off on it. There's some things I need to know about it. And then some brokers don't really care. They don't pay much attention to it. But I think it is a concern for the brokerage firm, as no matter how high up you go, Mark, that we have some control of what the agents are doing, because the agents don't always follow the securities rules. They just get their 3 or 4 friends and go out and buy that industrial building together. Well, if things go bad, I'm sure that the friends are going to go after the agent, and then that's going to spill over and going after the brokerage company. And I think you need to have some policies to talk about what can your licensees do in the world of securities.
And that was precisely my question. Thanks
There
for
you go.
addressing that. So the question then is, well, how do we check that the party bringing the offering to the market has got the appropriate FCC approval to do so?
Well, in a private placement, which is what all your people would be doing, they would have hired an attorney to draft a private placement memorandum, an operating agreement, and a subscription agreement. So I would require that the broker in charge see those documents. Okay. It might even take some education on the part of the broker in charge if they want their people to participate in this, which they don't necessarily have to, so that they could look at it and see what happens.
So that private placement offering, are you saying that must be prepared by legal counsel, or can the broker prepare that himself or herself?
I'm going to say it must be prepared by legal counsel.
Okay.
And I might have a conversation with you about that off off-site, okay, because I've got some ideas and it's not important to everyone, but I think that is an issue in running a brokerage business, because now you have an agent out there working with two sets of laws. What are the real estate laws pertaining to the licensing of that agent? And what are the securities laws? And if you're doing a deal that involves both of them, you're listing a property that you're going to buy, and you put together a group of investors to own it, you've got both sets of laws that you've got to be careful with. My advice to people that I run into who want to be syndicators, who ask me if they should go ahead and get a real estate license, is no, just stay away from that. Just be a syndicator. For a number of reasons, you're not going to make commissions anyhow on your securities offerings. So just stay away from that. And if you are already licensed and you want to be a syndicator, that's fine. What does your broker say? And let's follow the rules. And in the first couple chapters of my book, I talk quite a bit about the issue of being a syndicator and being a broker in the same set of rules. So it's something it'll be a good reading for the people who get the book. And I'll talk to you off-site, Mark.
Okay, thank you, Eugene.
Sure.
But your qualified investors, they have to sign that they received all the security filings. Okay, they can't even invest unless they sign off on reading that document.
Okay, that wasn't really a question. That was your comment. And your comment,
so is that correct? I'll rephrase it. Is that not correct, that if you're a qualified investor buying into a security position like that, you're actually, you have to acknowledge that you received how the structure was done and how it was basically how the Security Exchange Commission reviewed it. I mean, I've done private funding, private money funding, and we've had to go through 3 or 4 of those security exchanges and getting filed and how to do it. And every time we bring in an investment group, they have to be provided a copy of the return, especially if it's for profit. You have to demonstrate to them that this is how it's done. This is what the expected, now guarantees, but expectations. And then they have to acknowledge receipt of that. At least that's how it is on private money placement.
Well, okay. So a broader discussion of your comments, Brian, are that the private placement memorandum that I've mentioned, called a PPM, is the story. It's not a contract with anyone. It's the story.
Correct.
And it's the syndicator's responsibility to, and their official words are, give the investors all the important facts, the material facts, ahead of time so they can make an informed decision. So you give everyone this document, the private placement memorandum, and it's signed by the syndicator. Then you give them an operating agreement, which is the contract between the investors and the syndicator, and tells how everything is going to go. And in the old days, we had the syndicator sign the operating agreement, and all the investors sign the operating agreement. We don't do that anymore. We have a third document that really is what Brian's referring to, and it's called the subscription agreement. And in the subscription agreement, we restate all the risks from the syndicator to the investors. We restate everything that we've already said in the private placement. And then we have a certification from the investor, which Brian is talking about, which says, I've read everything. I've had a chance to ask any questions I want. My questions have been answered. I understand the risk. And here's my $50,000 check. Will you accept me as an investor? And then they sign that. And that is the document that's referred to in the operating agreement as where the investor's signature is, an agreement to follow the rules. Now, one thing Brian said that I kind of disagree with you, Brian, that applies to every investor, non-accredited or accredited investor. Everyone has to sign the subscription agreement, not just qualified.
Yeah, when we're doing a lot of our private placement, both for syndication for acquisition and for private money lending, we try to stay away from the non-accredited investors. It opens up a different risk and a different level of legal risk. It opens up a higher level of legal risk if you start accepting the non-accredited investors. So
Well, I
we've
think you're
always
right,
chose
Brian.
not to.
I
We've
think,
always
Brian,
chose not to.
yeah,
But
you're correct, because people who can fend for themselves don't need as much disclosure as people who can't. So the book's a little thicker if you're going to take non-accredited investors in there. That's fine. Anyone else with a question on this part?
Gene, I have a question similar to Mark's. It's kind of a two-pronged question, or an A-B question. And the first one is, since most of the people on the line, and probably most of the people who are going to be listening to this recording afterwards, are brokers in some capacity, is it not true that if there's a fee earned either on the way in or way out, they're entitled to keep that? And if it's earned on the way in, they also have a right to invest that like one of the investors. So they have their sponsorship share, whatever that might be, but they can also buy in if they use their commission or any other cash, just like any of the other investors. And then the second question would be, I guess it's a question, can you cover the 506 offerings, and I'll let you deal with the sub chapters or the letters that follow, and I'll mute back out.
Okay, we'll get to there. Let me answer the first question, because I kind of alluded to it when I said, if you asked me if you wanted to get a real estate license at the same time of being a syndicator, I would say no, because more than likely you can't take the fees. That's a securities rule, and here's where it is. You in the private placement memorandum, you list the sources and uses of funds. You're going to raise $1 million for the equity part. Now you have to tell the people, what are you doing with the $1 million? You don't worry about the debt part. It's just the equity part that you're getting from the investors. And in that disclosure, the securities laws say that if you're collecting a real estate commission going in, that typically is paid by the seller, right? It normally wouldn't show up on the list of what am I going to do with the $1 million that I'm raising, right? So you wouldn't know as an investor. So the SEC requires a footnote to your sources and uses document. And paraphrasing the footnote is, the sponsor is collecting a real estate commission from the seller. If the sponsor chose not, you're going to love this, if the sponsor chose not to collect a commission, it's likely that the property could have been purchased at a lower price. Required language. And that raises all sorts of problems, doesn't it, in communication and investing? So how we deal with that is we don't collect a commission. We have what's called maybe an acquisition fee or a due diligence fee that's paid out of the $1 million that's explained and disclosed. Well, that's all fine unless Sperry wants a commission on the deal you just bought. So how is that going to work? And that's a discussion for, the brokers and the agents to deal with. So it is a little complicated, but for sure, you're going to disclose it. Now, that's a silly disclosure. No one thinks that if you can buy a property without a commission, automatically the seller's going to drop the price. It might be fact, I don't know, but that's a disclosure that you have to put in there. So it is a problem. Okay, Neil, that's my answer to that question. And once again, when you read the first chapters of the book, you'll talk about that, why do you want to mix your brokerage business with your syndication business? I've had people who have started out as a broker, became a syndicator, dropped their brokerage business totally because of the conflicts. I've had people who go the other way, syndicator, and then want to be a broker, because in looking at deals for syndication, you find deals you don't want to do, but maybe someone would like to buy them. Maybe you'd like to do that brokerage. That makes some sense. And then, of course, I have people that do everything, do both ways, but they just have to be very, very careful. And it's all in disclosure. If you're I ran into this when I was a syndicator. Early on, I was doing some shopping centers or small retail centers in Minnesota, and I went into a meeting with a potential seller, and I wanted to make my listing presentation. And they immediately stopped me and they say, well, I know you buy properties just like mine. How about if you buy mine and I don't pay a commission? Well, that's kind of blows my listing presentation. That's awkward, right? And so you just say, well, I'd love to buy your property, but not at the price you want to sell it to me. So let's end that conversation. No, you probably don't say that, but it is a concern. Or if you're let's say you're walking with an agent, you're walking with a tenant who wants to list 10,000 square feet, and you've got a syndication and you've got a 10,000 square foot empty space, and you've got a listing with someone else who has a 10,000 square foot empty space. What are the conflicts of you showing that tenant to both of those spaces? Especially if the tenant knows that you own the building or you're responsible for the pricing on the building you're showing them. They'll be asking you questions. It's something to concern yourself about. There's no doubt about that. Neil asked a question about 506. Okay. Up until 1980, there was really no law about what a private placement was. And I was raising money in the 70s, and it was difficult. We didn't have any rules of accredited investors and non-accredited investors. We didn't have any of that. So 1980, the Securities Exchange Commission issued Regulation D, D as in dog, which is about private placements. And in Regulation D, they said, here's a type of offering you can do. And they called it a 506 offering. There were a couple types of offerings, but the one that was used the most was Rule 506. And in Rule 506, you could now, along with their new definition of accredited investors, you could take all the accredited investors you wanted because they could fend for themselves. We're not worried about that. But with the new definition of non-accredited investors, we're going to limit the number of those to 35 people because we're into investor protection. There's always the dichotomy in the securities world: capital formation and investor protection. And, they battled each other all the way down the line. But anyhow, so Rule 506 came out in 1980, and you could take up to 35 non-accredited investors and an unlimited number of accredited investors. And there was no limit to how much money you raised, and it went fine. Well, in 2012, the SEC came along and said, let's say Gene Trowbridge is still syndicating. Gene Trowbridge is out there trying to raise money, and there are investors out there trying to place money. But in our Rule 506, there's no advertising. You can't advertise to anyone. So Gene can't find the investors, and the investors can't find Gene. So we're going to allow advertising, but we're only going to allow advertising to people who can fend for themselves, because it gets to be a can of worms when you start advertising and making predictions and whatever online. So they came out and said, we're going to divide Rule 506 into two parts. The first part is going to be just exactly what it always was, 506B. Unlimited accredited, 35 non-accredited investors, no advertising. Everything was the same. But then we're going to institute 506C, which is for only accredited investors. And because they can all fend for themselves, we're going to allow the sponsor to advertise. Any type of advertising you can Any type of advertising you can think of is approved there. And so that's what we have now, 506C, 506B. Interesting, over the years, now it started in 2012, it's now 2026. 80% of the money that's raised in private placements is raised in 506B offerings, where there's no need for advertising, where you know the people that are going to invest with you. And the rest of the money, which is a smaller amount, is raised in 506C. What we found in 506C is advertising to people you don't know, especially if you don't have a track record, is not an effective way to market. So most of us get started, at least, marketing from the people who know us, who know that we're successful in our real estate career. And if, in fact, we had an opportunity and we could explore it, show it to them, they'd be likely to listen and possibly to invest with us. And then after we've done things for a couple of years and have some good history, maybe we can go out and advertise. But it's just not, 506C has just never been as popular as the government thought. So when you come to an attorney, one of the first questions the attorney is going to ask is, are you going to advertise? And then we have to go through a discussion of what does that mean? And we'll come up with an answer, well, yes or no. And if it's yes, you have to go 506C. And then if it's 506C, you can't use the people who are non-accredited. But there are all sorts of people who are non-accredited. If 80% of the money is raised in 506Bs, there must be a lot of people out there who are investing that are non-accredited. One of the reasons so much money is raised in 506B is stockbrokers sell private placements. And stockbrokers have a database. They have a Rolodex of people they know. They don't need to advertise. All the people have come to them through, financial planning products. And so they already know the people, so they don't want to advertise. So that's really why the big chunk of money is raised in 506B, is because you're going to be more successful asking people to invest with you if they know you. Okay, Neil?
Perfect. Thank you. Can I ask one follow-on question to probably part A? Just because I think people on the call and who listen to the recording are going to be thinking this question. If somebody, a broker, let's just say, or somebody listening to this recording, is going to put up all the initial monies, let's call it earnest money, legal fees, due diligence costs, maybe some third-party reports, on, and that costs them 30 grand, 50 grand, 100 grand or more, whatever it costs them. Is it not true that they can recoup those monies from the investors as part of their raise? So
absolutely,
not only are investors putting up money to own their share of the property, but they're also, part of their money is going to reimburse the sponsor or sponsors who laid out all the money in the first place.
Oh, absolutely. And we structure that in we talk about it in the PPM, and we structure it in the operating agreement. Let's give an example. Let's say you're going to raise $2 million. And $1 million of it is for CapEx. You're going to do all sorts of stuff to the building, and it's not going to be in the loan. It's going to be investor money. And so in the $1 million, you're going to close the transaction. So what we'd write an offering that says the minimum offering amount is $1 million and the maximum is $2 million. When you hit $1 million, the term is we break impounds. Now the sponsor can use the $1 million for whatever they need to do it. And one of the things is to reimburse themselves for all their upfront costs, and do prepaid insurance for the closing, and maybe the down payment is $750, but there's all sorts of things that you're going to need to do to get reimbursed. and have some working capital until you raise the extra million for the 2 million. So we structure all that. This is not a nothing down game, a no money down game. You're going to have some money to get started in your property search and getting control of a property. There's no doubt about that. Okay.
So my comment to that really is that's one of the best ways to identify whether the syndicator is, I'll put legitimate in quotes, because I review probably 10 to 12 syndication projects every month. And it's amazing how many of them have management fees and that upfront money that they're trying to recoup. Okay. Now, it's a definition of reasonable management fees or unreasonable management fees. But I've seen some projects in Northern Virginia where the manager is collecting, $300,000-$400,000 upfront of the first money to be done. He gets that upfront first. Usually you chalk that up to beware. So that's a good way to help qualify the syndications that you are looking at, is you really do pay attention to the placement memorandum.
Sure. And that's why it's the story. And in the sources and uses chart that we show, the SEC requires not just a breakdown of dollars and cents, but a breakdown of percentages. So, not every deal is exactly the same. One deal wants to raise 2 million, the next deal wants to raise 3.5. How do you compare those? Well, you compare it in the percentage columns. And going along with Brian's comment, when I'm working with my clients, I'm very cautious to make sure that the percentage of what I call front end load, what doesn't go into the property, that has to always be less than 8%. And it can be made up of a number of things, but collectively, it needs to be 8%. If it's more than 8%, you're going to get kickback on marketing. And one of the theories I think that you should teach is you should make money as your investors make money. Now, I don't mind being compensated, and I think you should be compensated for the 6 months you've spent trying to get this offering to the street. And you have due diligence, and you do all that, no question about that. But there's plenty of ways to make money in syndications at the same time that your investors make money. And that's one, a good marketing strategy, and two, a good legal strategy. I got a question right now. Scott, are you listening? Scott Owens? Are you there? I didn't mean, I know the microphone's
I am, Gene. I just had to unmute.
Where are you in Irvine?
I'm at the Sperry headquarter office.
Okay. I just have a note for you. No, I'm down here in Lake Forest.
Okay. Well, we can chat after this, or
we can do this. I'm just going to tell you one thing. My house is closing today. I am on my way to St. George, Utah. It's kind of been a battle, but I have a daughter and there's always a boy. So she got married, and so we're going to move up there, and maybe she can take care of us for the rest of our lives. I don't know, but anyhow, after 40 years in Irvine and Lake Forest, I'll be leaving. But I thought I recognized you, and I noticed the city. Okay, fine. Who else has a question on syndication and not my personal life? Robert, do you do any syndications?
Yeah, well, not anymore. I used to back when I was with PricewaterhouseCoopers. That's kind of how I got actively involved with syndications. We must have did 100 of them back in the 70s and early 80s before the 1986 Tax Act. We syndicated the 221D4, Section 8, 236 properties, and the question is not how much income you were getting in cash flow, it was how much loss you could generate for tax purposes. So,
boy, I'm glad you brought that up, because that I've been around a long time, and I've been through all the cycles and the ups and downs. And the 86 the 86 Reform Act was certainly a change, because the story was people were investing in see-through office buildings in Houston that never had any intention of being occupied, but they were getting a 4-to-1 write-off. And that certainly stopped with the addition of the passive loss rules, didn't it, Robert? Now it's an interesting situation. What are people syndicating today? Given the current tax law, there's all sorts of write-offs. There's bonus depreciation. There's cost segregation. We had a deal that closed in December of a client, and they raised $1 million to take over this property. That was the equity. And the first year losses coming back to the investors was $1.2 million. So we're back into the 1-to-1 write-off or 1+ write-off, which back in the old days, back in 80 through 86, caused people to do bad deals. Deals that were not economically feasible in the real estate standpoint, but no one cared because of all the losses that you had. And if you know anything about what happens to a negative capital account at the sale, there's all sorts of problems there. But I'm a little worried about that. You know what, and I think Neil mentioned the term distressed early in his introduction. A lot of syndications are done on multifamily, very much so. And I'm going to make a statement that anyone who put together a new multifamily deal from 2001 to 2003 is probably in default. Whether it's actual default or it's coming up or only the sponsor knows it's in default, maybe it hasn't got to the lender yet, but actually they are in default, and there's going to be some reckoning. So the question is this a good time to buy? Is it a good time to buy? You know, people were buying at cap rates of 3, and now it's at 6, and interest rates aren't 3, they're now at 6 or 7. Is it a good time to buy? And prices are going down, and investors, after they've helped 2 or 3 of their investments in negative capital calls, they don't have any more money. The sponsor doesn't have any more money. So I think as I say this, I'm saying there should be quite a few distressed properties, at least in that product type, coming on the market. Now, in saying that, I can count back to 5 different times in my career that I said that, and it actually never transpired.
Right.
We never really had the bloodbath that people expect. And bloodbaths generally happen when financing goes away. When the institutions, think about 2008, what was the real issue in 2008? The mortgage-backed securities industry collapsed. Now there was no financing. So that's really where it happened. So I don't know what's going to happen, but I do know that number one, a number of my clients who were doing nothing but multifamily have switched, and the choices are self-storage, mobile home parks, and RV parks. Now, I don't know what a multifamily syndicator knows about doing self-storage, but because I left the multifamily business way back in 1981 and spent 10 years in self-storage because I was looking for 800 units, 1 bathroom, and no one sleeping there overnight. And the best solution to that was self-storage. So that's interesting. That's a change that they're changing into a different product type, and I think that could cause some trouble. And I know in our firm, the other types of things that are being syndicated is really expanding. Last year, we did a barn of racehorses in Del Mar. We did a company that's doing fiber optic cables into apartment buildings. We did a semi-pro hockey team in Dallas. We did a liquor distillery in Reno. All sorts, probably 1 out of 5 things that we did last year were not real estate related. And it doesn't make any difference. It's still a security. people needed for all those things I talked about. They didn't have enough money to do it themselves, so they reached out to clients and they raised the money, and away we go. And I was just at a conference this weekend where a very large real estate syndicator, always doing apartment buildings, bought a chrome installation company and a water facility plant in Brownsville, Texas, as alternatives for investors that they had that just didn't want to go into multifamily at the present time. So,
Are you doing anything with data centers?
no, I haven't done a data center yet. I haven't done a data center. That would be a big
Yeah.
offering. They're expensive. That would be big.
Billion-dollar offerings. I'm
Sure.
working on a syndicate, trying to determine if a syndication would be the proper vehicle on a 2,200 acre. We're 6 months out from being fully entitled with power, but the dollars are insane. The front load dollars are in the 350 to 500 million range, and
Is
I
it
don't think.
revenue? Is it going to produce revenue?
Yeah, it's a phase one, which is only 150 acres of the entire project, is a $1.4 billion building that already has an LOI and a lease. So, but we're about my opinion only. I would love to speak more to that. My opinion would be that we are 6 months ahead of making that decision, but I'm not sure.
Okay. Well, it seems to me that if you can provide revenue, and I think we'd have to talk about the exit strategy. That's always, isn't
Yeah.
that important in real estate, guys? Ladies, we always talk about when we buy a property, what would be the appropriate time to exit? And when you're doing a syndication, you have to kind of spell that out to your investors, because not every investor is at a stage in their life that they want a 25-year investment.
Right.
Most of the deals we see today are 3 to 7, and with the possibility that maybe at the end of 7 years we might, or more likely at the end of 5 years when the loan comes due, we might refinance and carry it on a little farther. But don't be coming to me with all my gray hair with a 25-year holding period, because I'm not going to invest. So I don't know what the exit strategy is, and I don't want to talk about that anymore. Okay?
Yeah, well, the problem still holds to the fact that there's so many different points of exit strategy. So that's what I'm saying. We're premature on that.
Mhm.
But
there's one here right along the 405 freeway in Irvine that maybe Scott knows when he drives by there, that is a data center, and that's kind of interesting. I know a lot of you hear it on the news, and not every community actually wants that. So anyhow, okay, back to real estate
ask you one more
syndication.
question?
Yes.
Since you were talking about, tax benefits and TEFRA and all that a while ago, it got me thinking. Let's say you just bought I'm just going to make up a situation, a $5 million apartment building. If you're an individual owner, you can depreciate that over 27 and a half years. Can the investors in a syndication or a group offering or whatever you want to call it, can they take advantage of 27 and a half year or 39-year depreciation?
27. It's a residential asset, and the depreciation schedule is 27 and a half years. And today they do cost segregation. They go into that
they
apartment
could get
building.
their share. They would get their share based on, I guess, their pro rata investment.
Sure. So
and they can also take
attractive
advantage
today.
of a cost segregation.
Sure. And bonus depreciation. I have a great client up in New York State who does car washes. Well, what is car wash? It's a bunch of metal stuck in a piece of dirt. And through bonus depreciation, cost segregation, it's huge write-offs, and they provide revenue. I don't know what the future is. I don't know how long they last and what the exit strategy is, but she has no problem raising raising money for that. So what's happening today in 20 and 21, the market was extremely hot. Everyone was doing syndication. Everyone with a pulse was a syndicator. But a lot of things happened, in 2018 and 19, we weren't writing in our PPMs the potential of a pandemic that, at least in multifamily, caused all sorts of problems because in some areas tenants didn't have to pay rent. You could never inspect the properties, or all sorts of problems. And then, of course, in 2002, what happened is interest rates started. What did the Fed raise interest rates 18 times or something? That doesn't help much when you're on a 5-year bridge loan. So there's been all sorts of slowing down. 2023 and 2024, our business was basically half of what it was in the earlier days. The last 6 months have picked up quite a bit. A lot of people are deciding that I guess they're deciding that sellers have come to understand what the new market values are and realize that they're going to have to sell to take care of their loan situation. So we do have businesses popping up. All the other, I'm not going to call myself a guru, but I hear a lot of gurus on this industry think that 2006 is going to be an industry that's going to be taking off. And in 2007, we're going to have a very strong real estate industry, which is good for syndication. I suppose you guys have your own, Sperry has your own research department, and maybe you're thinking that good things are going to happen going forward. And I hope that's the case.
Gene, can we please get your phone number and email address so they can hear it on the call, but also it's part of the recording?
Can you put it in the chat?
I will. Go ahead.
Okay, well, my phone number, call me directly, my cell, 949-855-8399.
One more time, if you don't mind.
949
Yes.
855-8399. So that's my cell, and that's my office phone. So you can text me, you can call me, whatever. And to get to me, email, it's simple. It's Gene, Gene, at T as in Tom, N as in Nancy, LLP.com.
Gene, I'm just a little bit slow. I just hit send on the phone number. Can you do the email address one more time?
Gene, Gene, at T as in Tom, N as in Nancy, LLP.
Okay. Perfect.
So that's good. If you want to go to my website and really maybe register or sign up on my YouTube channel, I post a lot of stuff. I've been an educator. I was a CCIM instructor for 40 years, and my whole world is education-based marketing. So there's all sorts of stuff I talk about. The most current one I have out there is a problem with capital accounts. What do investors think when they invest in a deal and they think they're going to get all this write-off, and they get their K-1 with write-offs, but they take it to the CPA for the tax return, and the CPA says you can't use the write-offs this year. That's an interesting educational event. So Neil, thanks for having me.
Real quick, can you give us the URL, the website real quick? I'm putting that in the chat as well.
TNLLP.com.
www.tnllp.com.
And when I'm through here, Neil, I'll email you the PDF of the 5th version, and you can distribute it to anyone you want. Okay?
Please do. I will distribute it right away. It's funny when you say that. I had a flashback. I don't know if that was your first 2, but at least 2 of your first 4, I guess. If I'm not mistaken, the first one I have is in a binder, a 3-ring binder.
Correct.
Second one's a a paper-bound book, a pretty good size, pretty thick book. So anyway, I'm looking for, and I've read both of those, and they're still on my library, but I'm looking forward to receiving that one, and I will circulate it to everybody. You know, a couple of hundred people got this invite, and they'll all
Great.
get the recording
Send
and
it out.
your book.
Okay, they'll never get a business card from me, but they'll get my book. Okay.
Perfect. Well,
Eugene, Neil, it's Mark Hinkins again. Thanks for this. This has been fantastic. Really appreciate you taking the time. I know
you're
that
quite
it was
welcome.
very well received across the Sperry network and the
Good.
guests that were invited. Good luck with the move, Eugene. Congrats on that. And I'll give you a call in a couple of weeks' time once you're settled in to follow up on the conversation we had at the beginning.
Yeah, that'll be great because I have some ideas on that. Yeah, we're closing today, but I have 30 days to stay here because I have no place to go.
Oh,
As of tomorrow, I'm homeless, but a lot of money in the bank. Okay. All right.
Thank you so
Thanks.
much, Gene.
Thanks,
Nice to see you.
everyone.
Nice to see all of you, ladies and gentlemen.
Nice to see
Thank
you
you.
too.
Bye.
Take care. Bye-bye.